In the fall of 2023, an employer in Sarasota, Florida, received a citation from the Occupational Safety and Health Administration. The employer issued a notice of its intent to contest the citation. Unfortunately, the employer filed its notice of contest about 4.5 months after the filing deadline. This employer issued arguments before the administrative law judge as to why the extension of time should be recognized and the employer's late filing should be excused. And the administrative law judge, having heard arguments from both sides, issued a ruling in that case. I think it's an important case for all employers to understand, and we're going to talk about the arguments on both sides and the administrative law judge's reasoning and the administrative law judge's holding in this, the December 2024 episode of the OSHA 3030. Well, hello, everyone, and welcome to the OSHA 3030. I'm Manesh, Rath. I'm a partner at the law firm Keller and Heckman. I'm here in our Washington, D.C. office, and I'm joined today by my colleague and a member of our OSHA law team here at Keller and Heckman, Ben Idzik. Ben, welcome to the OSHA 3030.
Thank you. It's a privilege to be on.
First time on the OSHA 3030, if I'm not mistaken?
That's correct.
Well, this is great, and I look forward to doing a lot of episodes with you. This will be an important issue that this administrative law judge sat on that I think that the members of the OSHA 3030 community will greatly benefit from. So thank you for joining me on this and sharing this case with our community members. So Ben, why don't we get right into it? Let's talk about what we're going to talk about today. I think the first thing we should talk about is let's talk about the facts in this case. The case is Secretary versus Blue Water Yachting Solutions Incorporated. Blue Water Yachting Solutions, an employer in Sarasota, Florida.
Correct. That's the case name. And next, we're going to dive into the rules for noticing a contest. And we're also going to touch upon the arguments for excusing delay of submissions of a notice of contest.
So those are very limited arguments that courts will recognize or administrative law judges will recognize. And so we're going to find out how the administrative law judge treated those arguments in this case and talk about the judge's reasoning and findings. Finally, we're going to talk about what employers should do in light of this case, the practical takeaway items that we always try and wrap up our OSHA 3030 episodes with. So with that said, Ben, why don't we get right into it? Let's talk about the facts in this case. So it starts with an inspection. The Occupational Safety and Health Administration, Florida, is a federal state, and so this was the U.S. Occupational Safety and Health Administration. And a compliance officer comes in and conducts an inspection in September of last year, 2023.
Right, that's correct. The inspection was conducted, like you said, on September 26, 2023. OSHA turned around and issued a citation on October 18th, 2023. And then it sent by certified mail a citation to Blue Water on October 23rd.
So this was sent by certified mail, which means we know not only the date that it was sent, but the date that it was received by Blue Water.
That's correct. Yep.
So Blue Water contends to the administrative law judge that it sent, in response to this citation that it received by certified mail, that it sent a notice of contest, a statement expressing its intent to contest these citations and requesting that a hearing be conducted. And Blue Water contends that it issued this notice of contest on November 9th of 2023, or only some 8 plus 9, about 17 days after, calendar days after the receipt of the citation. And that's interesting. The deadline, they claim that they sent it on November 9th. The deadline for having filed a notice of contest would have been November 14th, the 15th working day after the receipt of the citation. So their deadline would have been November 14th. They claim they sent it ahead of time, November 9th.
Right, exactly right. And then that's going to really be the linchpin of this entire matter that I think is going to be really important to dive into.
Right. And so the review commission states that the notice of contest that Blue Water actually sent was received by the review commission as well as by the Occupational Safety and Health Administration on March 27th, or some 4.5 months later. It was addressed to the review commission, and on its face, it purported to be CC'd to the area director of the Occupational Safety and Health Administration, but there's no evidence that it was sent to the area director. And the notice of contest letter that the review commission received on its face did not have a date.
That's correct. No,
which
that
I think is interesting
is
that any correspondence with an enforcement agency, I think you should date your correspondence to keep track of when things were sent or when things were drafted at the very least. So that is, I think, the important dates in the timeline of events that form the basis of the arguments between Blue Water and OSHA before the administrative law judge. Okay. Remember, 4.5 months after the end of the notice of contest period, the review commission received the notice of contest. Let's talk, Ben, about just trying to set straight what OSHA must do when it issues a citation in order to establish that it had done so properly.
right. So the first thing is that OSHA bears the burden of establishing that it served notice properly. And really, it boils down to two things. One, it has to be sent via certified mail, and it also has to be sufficiently detailed.
Well, that's right. So the citation, obviously, it has to be a written citation, and it has to be sent by certified mail. That certified mail process will establish the address to which it was delivered, the date on which it was delivered, and that somebody, in fact, received it. And the other requirement that you're talking about, Ben, is that somebody, an objective, reasonable person looking at the content of the citation itself has to be able to say that the allegations made in the citation by OSHA sufficiently inform the employer of the nature of the allegation against it in order to provide the employer with sufficient information to debate or decide whether or not to contest the citation. If on the face of the allegations, it's so ambiguous that the employer does not know what alleged violation they're being charged with, they could make theoretically the argument that that 15 days limit for filing a notice of contest was insufficient, even though that's the hard and fast limit, that was insufficient because there just wasn't enough information in the citation itself for the employer to have made a proper evaluation of whether to contest the citation. So those are the critical requirements on the face of the regulation as to what OSHA's burden is when issuing a citation so this is the key. These are the requirements on OSHA in order to be able to enforce the 15 days, to hold the employer's feet to the fire on the 15-day limit. Yeah. I think this is important because I don't want anyone to mistake this last point that the citation has to be sufficiently clear on its face as to what the nature of the allegation is, as implying that an insufficiently clear citation would therefore fail as a citation, and that the employer may, on that basis, have sufficient grounds to move to vacate the citation. I don't think that that's what this section, regulatory section, implies. It implies that the 15-day limit may lose its enforceability in the face of a citation that is insufficiently specific as to the nature of the allegations against the employer. So therefore, the penalty against OSHA, I do not see the penalty as being that the citation would fail or would warrant being vacated. I see it as the penalty being perhaps an enlargement of the 15-day period. And this is important, Ben, because if an employer sees an ambiguous citation, insufficiently specific, but nevertheless notices timely their notice of the agency of their notice of their intent to contest, then they have essentially waived any arguments as to whether the insufficiency of the allegations would merit larger time, because they have established that they didn't need larger time. They've timely noticed their contest. It would only be a material requirement upon OSHA in the event that the employer filed a late or sought to file a late notice of contest and established that one of the bases for doing so was the insufficiency of specificity that OSHA mistakenly or ambiguously laid forth on the face of their citation.
Absolutely right.
So I think that would be the only remedy available under this section, at least, is that it would enable the employer to enlarge time. But they may have foregone that remedy by timely notifying the agency of their intent to contest anyways.
Right.
Okay, an important point. Let's move on. Let's talk about that notice of contest deadline. So we talked about 15 days?
15 days, that's correct. And Importantly, within this context, 15 days it excludes only Saturdays, Sundays, and federal holidays.
I think the other important point is we're talking about 15 working days,
Right.
not 15 calendar days. So let's go back. The citation was issued on October 18th. 15 calendar days from then would have been somewhere in the neighborhood of November 2, but 15 working days turns out to be November 14. And so that 15 working days is really critical to be mindful of. And Ben, your point is?
And on top of that, it excludes Saturdays, Sundays, and federal holidays.
That's an excellent point. So working days is a specific exclusion. It is not dependent on what you, the employer, established as your working days. It goes to Monday through Friday serially until you get to 15 working days, and you may only exclude from counting 15 serial days, you may only exclude Saturdays, Sundays, and federally recognized holidays from that count in order to get to 15 working days. It may be that you may be able to persuade an administrative law judge that there may be other days that should be excluded equitably, but not on the face of this requirement. This shows up on the face of the requirement with the word only.
Correct. Yes.
So that's important. So those are the only days you can subtract out of your count are Saturday, Sundays, and federally recognized holidays.
Right. Exactly. And on top of that, it also would make sure that the notice of contest is delivered to the area director at the area office that issued the actual citation.
Yeah, I think that was a problem in the Blue Water case, wasn't it?
Exactly.
That he may have sent it to the review commission,
Right.
and on the face of the contents of his missive, it appears that he may have intended to CC the area director. The area director said that they never received anything.
Right.
But on the face of his notice of contest, it said he intended to CC the area director. But in fact, I think even on the face of that document, he would have had it backwards in the rule that you're citing to now.
Correct.
The notice of contest should be directed to the area director.
That's right.
If you want to CC other people, that would be fine. But the strange thing about that document is that the review commission would not have been invoked at that stage that the 15th working day would have been triggered, because the process is you first file a notice of contest, then the Occupational Safety and Health Administration prepares a complaint and notifies the review commission. And that's when a case gets opened up with the review commission.
That's exactly right.
So the review commission, their name, their address, everything about sending it to them would be premature for certain at the time, if you're working within the 15 working days limit, which we recognize that may not have been the case here. But that the area director is really the only participant that's relevant at that stage, that 15th working day, for the purposes of issuing a notice of contest.
Right.
Yeah, great point. I'm glad you brought it up, Ben. Well, let's talk about that 15-day working day rule. It has to be read, according to the administrative law judge in this case, in conjunction with the federal rules of civil procedure. And Rule 60 in the Federal Rules of Civil Procedure, which do not operate on the contest process for OSHA law, but they are relied on heavily when evaluating these kinds of disputes. The Federal Rules of Civil Procedure, and were recognized by this administrative law judge as good guidance. The Federal Rules of Civil Procedure allow for enlargement of time for time limits throughout the rules. In very specific limited cases. One of them is if there's a danger of prejudice to the party seeking the enlargement. The other thing that the judge will evaluate is the prejudice to the party against whom the time is enlarged, in this case OSHA, whether any prejudice flows to OSHA by granting an enlargement. And I think that question of prejudice is almost always the first point that counsel on both sides make when talking about equitable enlargement of time limits.
Exactly right. Yep. And then it also goes that another factor we consider is the reason for the delay, whether the reason of delay was out of the employer's control. And also very related to that is whether the employer acted in good faith in making a delayed submission.
Okay, so the danger of prejudice to either side will be argued by both sides, the impact of the delay, how much delay we're talking about, and then, as you say, the basis, the grounds that the employer is urging the court to consider for why he seeks a delay, and specifically whether those grounds he's providing are ones that were out of the employer's control or whether he could have done something about it anyways.
Right.
Sure, they sound sympathetic, like sympathetic reasons, but the employer could have done something to mitigate them. Those would be the kinds of things that a judge will consider when applying Federal Rule 60. That's I think the kind of argument that you'll see over and over and over again in any federal case where parties are seeking enlargement of a time limit. And so the judge applied those elements in this case as well, in the Blue Water case.
Right.
Blue Water's argument, following those four elements that we just discussed, Blue Water argued that, first of all, it did mail the notice of contest in a timely manner. Its deadline was November 14 of 2023. And Blue Water argued, well, we did mail it on November 9th. I don't know, Blue Water asserted, why it didn't get to the area director or why it only got to the review commission in March of the following calendar year. But Blue Water argues we did mail it on November 9th.
Right. And the difficulty with trying to figure out the exact date, and just even aside from how late it came, was the fact that, like you mentioned, the notice was not dated.
They didn't date their document, but they also, as you'd pointed out about OSHA's burden to issue this by certified mail, Blue Water could have, if it wished to, it could have sent this in some method that would have stamped the date by a courier, perhaps.
Yep.
Certified mail, certainly. Overnight express like FedEx. FedEx doesn't miss, and they have a track record. They have a receipt that they issue of the date that it was picked up and the date it was delivered. And to me, that's a method of choice. But certified mail is also equally persuasive as to the date of issuance in the event that it didn't get received. That certified mail pickup date is persuasive that at least it was posted on that date.
Right.
The problem with sending it non-certified is you can get a postmark, but if the mail should disappear en route, then you don't have that postmark. Whereas the certified mail, you would get a copy of the strip that you tear off on the certified mail sticker.
Right.
So in addition to not dating the document that they mailed that was received by the notice was received by the review commission, they may have used the incorrect address when mailing it. Specifically, not to the area director, but to the review commission as well. These are a host of problems in Blue Water's argument that it mailed it timely, but I think maybe one more important point that needs to be mentioned, Ben, they're not arguing for any of the four elements that the administrative law judge set forth under Rule 60 of the Federal Rules of Civil Procedure. They're not saying that there was a circumstance that was excusable neglect that was out of their control and that they acted in good faith, and they're not arguing that there was any problem with prejudice or the impact of the delay. They're saying that they did indeed mail it on time, in a timely manner. They're asserting that they mailed it on November 9th, leaving the judge to us apply those four elements on its own.
Right, exactly right. Yeah, and so when we get to the ALJ's decision, Manesh, we figure out that, first of all, the judge does recognize that even though the notice of contest was submitted late, it said, okay, that there is not a prejudice to OSHA for the delay. The delay would not impact the commission's proceedings. There was also no evidence that Blue Water acted in good faith, which is important to recognize because the commission pretty emphatically, the ALJ, pretty emphatically noted that good faith alone would not be sufficient to excuse a late submission of a notice of contest.
Right, then why list it as one of the elements?
Right.
It is an element that has to be read in concert with the other elements. I do think they left open the question of whether if there's excusable neglect but a lack of good faith. I think that they're implying that that would not be sufficient, that you need both excusable neglect and good faith. And I think that's where I was going with this idea that if there's excusable neglect, the employer has to show that they did their best to mitigate or overcome whatever circumstance came outside of their control. So all three of those elements really have to be read in concert. One singular fact goes to good faith, excusable neglect, and within the control of the employer. And it's either favorable in all three dimensions or it's fatal in any of those dimensions, and so the employer will fail. So yeah, you're right. That's a great point, that when the judge said that it doesn't matter whether Blue Water acted in good faith, they didn't apply any evidence. They didn't submit any evidence of good faith. But in any event, good faith by itself wouldn't have been sufficient to require the judge to toll the limitation period. Ultimately, what they found was that there's simply a lack of evidence on any of these points. On the question of good faith or excusable neglect, Blue Water did not submit evidence as to what the basis for excusable neglect would be, and their assertion that they mailed it on November 9th lacked evidence as well. It wouldn't matter whether or not the judge had to make a credibility finding as to whether Blue Water mailed a notice of contest on November 9th. Blue Water submitted no evidence. They didn't supply, for example, as we talked about, the certified receipt or the FedEx receipt,
Right.
or any other kind of proof, a courier, that would have permitted the judge to credit Blue Water's assertions.
Exactly. And I think that an equally important point is the fact that, the judge emphasized how Blue Water had control over the delay. It wasn't any outside circumstances that caused the delay. It was within their purview, and they couldn't live up to the requirements of the rule.
Yeah, that's right. So let's talk about whether or not employers theoretically could persuade an administrative law judge to toll the 15 days or enlarge the 15 days to accept a late filing. I often say we teach safety and health professionals around the country, and I often say that on this point, when we come around to this subject, that the number of cases where an employer has successfully argued for an enlargement of the 15-day notice of contest limit can be counted on the fingers of one hand in the whole of the 54-year history of OSHA law. Now, I've never actually taken count, so that may be slightly inaccurate, but it's somewhere in that neighborhood. In all of those years, there haven't been many cases where an employer has victoriously asserted an enlargement of the notice of contest period. Let's talk about two of them.
Sure. Yeah. Like you mentioned, Manesh, they're very rare. And many of them have to do with mailing issues. So sometimes the mailing issues on the part of the agency. So we have situations in which OSHA sent the citation notice to the wrong employer address, the wrong corporate office. Or another instance involving mail is that it was sent not using certified mail, which is required by the statute.
Yeah, so this isn't really, when you think about it, an argument as to why the 15 days should be enlarged. This is an argument for why the day that begins the 15-day period should be set forward. The employer is essentially arguing in those particular cases, I didn't receive it on the date you think I received it.
Exactly.
And so you should count 15 days forward from there because it was sent to the wrong address. And there was at least one case recently. The case you're talking about, I think, goes back to 1979. But there was a case recently, maybe about 5 years ago, somewhere in that neighborhood, where the house number was, instead of 1001, it was like 100001. And that typographical did foil the post office in its delivery of that mail. But that's not really a basis for expanding the 15 days to a larger number. It is a basis for why the receipt date that OSHA is asserting was an inaccurate receipt date.
Right, exactly.
So even that doesn't qualify as an example of a case where an employer was successful in tolling the 15 days. There are other examples, though. One case in 1999, I think, an employer argued that he had a miscommunication with his attorney. This sort of conversation went back and forth between him and his attorney that, okay, I thought you were going to mail the document. You said you were going to mail the notice of contest. And the attorney said, no, I thought I was going to draft it and you were going to mail the notice of contest. And when the administrative law judge heard that, he found that to be a plausible basis for allowing a late filing. That surprises me, to be honest. I would not promise our members of the OSHA 3030 community that they could assert that basis and prevail again. I think that would be maybe more of idiosyncratic outcome. And it may be that in the mind of that particular administrative law judge, whom for all we know may not be on the bench. I didn't look at which judge it was. Don't expect to get that judge again. but it may be that what was on the mind of that judge was that it wouldn't be fair to the employer to penalize them for a mistake that seemed apparent to the judge to have been the mistake of the attorney.
Right. And I think also a major difference between the situation with Blue Water is the fact that in this case we're just discussing the citation or the notice of contest was only submitted 1 day past the deadline.
In that 1999 case, is that right?
Right.
Well, that's a great point, Ben. Good catch. So, when you're asking for only 1 day additional excuse and you have this miscommunication between you and your attorney, and the judge doesn't want to penalize the employer for a mistake made by the attorney, that goes back to one of the elements we talked about, which is the length of delay.
Right.
And how much prejudice could OSHA have suffered from just 1 day's delay.
Right.
That's an extraordinary fact pattern. So I'm glad you brought up that it was only 1 day in that case. And that illustrates the point, though, how difficult our members of our OSHA 3030 community should view the task of trying to get a judge to agree with them to accept a late filing. I wouldn't advise it. I think at all costs, the employer has to get that notice of contest filed on time if it has any intention of filing a notice of contest. And let me be clear, by the way, to put this in context, the penalty for not filing a notice of contest on time is that it is treated as a guilty plea. And that's sort of the end of the show. You don't have any opportunity to argue on the merits of a citation. And this could be particularly unfortunate for an employer if the employer believes that the citation was incorrectly issued and that there are terrific defenses available to the employer because the citation the employer believes was incorrectly issued and yet missed the deadline. The effect is to have pled guilty to that incorrectly issued citation, and that's a real unfortunate outcome. So by all means, that deadline has to be met.
Exactly.
With that said, let's talk about what we think employers should do in light of the Blue Water Yachting Solutions case. Well, I think the first thing, Ben, we talk about this all the time with our employers, is at the establishment level. So if you are a multi-establishment employer, then at every establishment that you're operating, there has to be a training process for the person who receives the mail to notice anything that's certified mail, and as well anything that comes from an enforcement agency, and make sure that gets into the hands of and under the eyes of the managing staff member for that establishment immediately without any delay. If that managing staff member is out on business travel or vacation, to scan it right then and there and send it electronically, and then to follow up with a phone call to make sure they got it. If that person is out for the day, to make sure that that's the first order of business to present to them when they come back. That 15-day deadline, there's a lot of work that needs to be done during that 15 days. So on day one, it really needs to be elevated to the attention of the person who's empowered to make decisions about what to do with that citation.
Exactly.
So that they have the benefit of the full 15 days to gather enough information to make informed decisions.
Exactly. And it's important also to the next point, to manage the contest schedule independently of any informal conferences or telephone calls or emails or other resolution efforts with OSHA. Even though you may have other contacts with OSHA during the period which the citation is issued, that does not toll the actual 15-day period. And I think this was one of the issues that sort of was on the periphery of this case, where Blue Water claimed that it had a conference with OSHA.
An informal conference?
An informal conference, exactly, with OSHA, during which they mentioned that they were planning on contesting the citation. But ultimately, that didn't really hold up at the LAJ stage, like we saw.
Yeah, that's right. That's right. So in between the two, in between training the staff and the receipt of it and knowing how to elevate these kinds of certified mail that come from enforcement agencies and managing that process through the informal conference, the team that's going to make a decision about whether to contest the citation has to get together, perhaps with OSHA counsel, but they have to evaluate what are the bona fides of the allegations. Was the citation issued correctly or incorrectly or based on incorrect facts? Correct or incorrect, are there valid defenses to this alleged violation? And all of that has to be evaluated, again, preferably with OSHA counsel. And that takes time. Some of the facts that the occupational safety and health compliance officer has, the decision makers and your outside OSHA counsel do not yet have and will take time to gather in order to just catch up to where the compliance officer already was at the moment of drafting the citation and the alleged violation description. The other thing I'd say is there's multiple elements to a notice of contest, and they all have to be evaluated. An employer may decide to contest the alleged violation, but not other elements of the citation, or conversely, may decide not to contest the alleged violation, but may contest the penalty amount or the time to abate. All of these elements and several others have to be identified in a notice of contest, and the grounds for the contest need to be carefully considered and communicated in order to arrive at a sound decision to issue a notice of contest and what should go into the notice of contest.
Right.
And then finally, as you say, Ben, then I think that the employer has to be mindful of that 15-day schedule and not allow the informal conference or any correspondences or follow-up requests for information from the compliance officer to trip up the employer's ability to comply with that 15-day notice of contest. What happens is with the informal conference, oftentimes the compliance officer might say, well, we've raised a few issues. Let me go ahead and go back to my office and look into them and get back to you after the citation's been issued. And that may lead some employers to the mistaken belief that while the compliance officer is looking into something, that they don't have any duty to issue a notice of contest. But nothing about what the compliance officer said tolls that 15 days. So if the compliance officer says, I'm going to get back to you, and then fails to do so on the 15th day, I wouldn't wait another day. I would make your decision as to whether you're going to contest and issue that contest with or without a timely response from the compliance officer that the compliance officer had promised that they would offer. And so that is what we mean when we say that this process for managing the schedule has to be managed independently of all these other sort of parallel activity. I think that that's something that probably trips up a lot of employers. And I want to point out, by the way, in fairness to Blue Water and all of the other employers out there who found themselves over the years in Blue Water's situation, Blue Water, from all outward appearances, appears to me to be a small employer. And they did not engage outside counsel, which I think was maybe contributed to some of the decisions that they made. But that they handled the case on their own. I would certainly encourage employers to give themselves the benefit of experienced OSHA counsel to walk them through this process, because I don't think that the decisions that Blue Water made that led to the unfavorable outcome from the administrative law judge were necessary. I think that this could have been avoidable. And this is particularly unfortunate because there may have been bona fide defenses to the citations. The citations, we should point out, were fairly picayune administrative paperwork kind of requirements. One was about powered industrial trucks and the duty to inspect equipment at the end of every shift.
Correct. Yeah.
And the other was respirators.
Yeah, respiratory protection standard. Yeah.
Yeah, but it was specifically maybe fit testing.
Yes, fit testing. Correct.
And so these are, maybe if they conducted an inspection and those are the only two things they came up with, then for all we know, there could have been good defenses. Yeah. And we'll never get to find out because, and in part because without the benefits of outside OSHA counsel, Blue Water failed to get past the notice of contest issue and struck out at that point, went back to the dugout. So that's what employers should do. With that in mind, I think the other thing I'd say is record keeping for the employer. Right. That counsel can walk them through things like records of facts that support an argument for excusable neglect. Yeah. Medical records if the reason was hospitalization or uncontrollable medical events, something like that.
Exactly. And also relating to the keeping records of certified mail, like when you received it, when you sent it out, to have in the event that something goes wrong, to go back and be able to show OSHA hard evidence that this is when we responded to the citation. This is when. Yeah,
just scan it in and keep a record of it electronically so that it doesn't get lost. And then any correspondences with the compliance officer that would enable you to make equitable arguments as to what was going on between OSHA and the employer at the time are things that have to be, records that have to be maintained. And that means that have to be done in writing, or if it's done by phone, I think that they need to be memorialized in writing shortly afterwards. So that's what we think employers should do in light of the Blue Water yachting case. That's today's OSHA 3030, Ben. I want to point out for members of the OSHA 3030 community, two of our sister programs are coming up soon. January 8th, the Tosca 3030. I enjoyed meeting many of you at our Tosca program here in Arlington, Virginia. Keller and Heckman held about 2-3 weeks ago, just about a week before Thanksgiving. And it was great to meet all of you there. Stay tuned for other in-person programming from our Tosca team. Incredibly talented group of a large number of attorneys who work in the field of Tosca law. And their next webinar is going to be January 8th, 2025 at 1 p.m. Eastern. And our Reach 3030, February 12th, 2025 at 10 a.m. Eastern Time. Our next program, the OSHA 3030, will come back in 2025,
Right.
probably for our 13th calendar year. I sometimes get that number wrong, maybe stretch it a little bit, but I think we're starting our 13th calendar year, somewhere in there. And we'll be back January 15th at 1 p.m. Eastern Time, always on a Wednesday, always at 1 p.m. Eastern Time. We're going to see you again then. We hope that you have a happy holiday, and we look forward to seeing you again on January 15th. And until then, stay safe.